Live. A very good evening and welcome to a brand new edition of Face to Face, coming to you direct from our Newsfirst studios in Colombo, bringing you tonight's episode. I am Gehan Gunatilleke, and tonight my guest is no stranger on the show. He is Dr. Gehan Gunatilleke, attorney at law and also a commissioner at the Human Rights Commission of Sri Lanka. A very good evening to you, Dr. Gehan.
Good
Welcome
evening.
back on the show.
Yeah, and thank you for inviting me. Thank you. Yeah.
Dr. Gehan, I believe your appearance on Face to Face this evening comes at a very prudent time because the 60th UNHRC sessions commenced in Geneva yesterday, the 8th of September, and Sri Lanka's human rights record was brought under scrutiny once more, with the report being published by the High Commissioner for Human Rights, Volker Turk, urging Sri Lanka to agree on international prosecution processes for alleged war crimes. Now, the Human Rights Commissioner, Volker Turk, identified three critical pillars in his report. I will explain that to our viewers for their information. It outlined delivering accountability and justice, undertaking deep constitutional, legal and institutional reforms, and eliminating discrimination and political division. Now, Foreign Minister Vijita Herath is also in Geneva, and he addressed the Human Rights Council yesterday as well. And delivering his address, the Foreign Minister said that the government opposes any external mechanisms such as the Sri Lanka Accountability Project, claiming it would create divisions and disrupt the reconciliation process that is currently underway. And he also announced that the much controversial PTA, or the Prevention of Terrorism Act, will be repealed and the Online Safety Act will be amended. Dr. Gehan, taking all of this into context, the Human Rights Commission, the current government's strong crackdown on the rule of law to ensure the rule of law against injustices, corruption, crimes and so on. How best do you believe Sri Lanka can engage with the UN Human Rights Commission in a way that is constructive and credible from both domestic governance aspects and also international confidence perspective?
Yeah, so I think that it's important to first realize that this is not a new process. This is a process that began back in 2009 after the conclusion of the armed conflict. The Human Rights Council has had a continuous interest in Sri Lanka as a country that there are allegations against which there are allegations of gross human rights violations. And from 2012 onwards, there has been always this resolution on Sri Lanka. I don't want to frame it as a resolution against Sri Lanka, because we have to ask the question, what is Sri Lanka? Who is Sri Lanka? And if there are victims of atrocities, victims of human rights violations that are demanding some accountability, this sort of resolution should not be viewed as a resolution against Sri Lanka. It is a resolution on Sri Lanka, because it concerns Sri Lankans ultimately people. And Sri Lankan people, because people who represent Sri Lanka at these various fora or who are part of the political leadership shouldn't mistake themselves as being the country. The country constitutes people. The people. And the people have had a say in this matter, and there have been segments of the Sri Lankan population that have demanded an international process. And starting with 2012, there have been continuous resolutions on Sri Lanka. Now these resolutions, if we break them down and ask what is in the resolutions, I wouldn't say that the resolutions are entirely unreasonable. Now if you take the first resolution back in 2012, what it asked fundamentally the government of that time to do was to implement the constructive recommendations of the Lessons Learned and Reconciliation Commission. That was the main takeaway of that resolution. That's where it all started. So there was a Lessons Learned and Reconciliation Commission that was appointed at the time by that government. The LLRC had various recommendations. Some of those recommendations were actually quite important and they were constructive. And that resolution actually framed its content based entirely, not entirely, but mostly on the LLRC's constructive recommendations and asked the government to implement them. So that was the starting point. Now, if you recall, that was a domestic process. Now we have come to 2025 and there are demands for international process.
Yes.
But that was fundamentally a domestic process, and that's where it all began. Then 2013, 2014, 2015, you had the same sort of demand. Implement your constructive recommendations of your domestic process. That was the fundamental demand.
Yes.
In 2015, something changed when the government changed. The government of that time decided to actually co-sponsor a resolution.
Yes.
And that was actually quite unprecedented for a government to say, okay, we are going to now come and co-sponsor a resolution on us, in the sense on the country.
Yeah.
And there the government agreed to a very ambitious list of various initiatives and interventions that it would do over a particular period of time.
Right.
Again, because the government is co-sponsoring, it is still very much a domestic process.
So it undertook it on its own accord.
That's right. So then again, the Human Rights Council, like it wanted the government to implement the LLRC's constructive recommendations, then decides to give the government a chance to implement its own agenda.
Yeah.
Right. So it's still very much domestic centered. Now, by this time, still very little progress had been made on a truth-seeking mechanism, on reparations for victims of the armed conflict, on accountability for crimes committed both during and in the aftermath of the conflict. And crimes were committed. If you look at the enforced disappearances that took place during the final stages of the war, and just afterwards, clearly there were crimes committed. So there is a responsibility to investigate that.
Yes.
Now, up to that point, it's clearly a domestic process, but very little progress. So by that time, there's already some skepticism building up amongst the victim communities that, we are not going to be able to trust a local process. But this co-sponsorship bought some time for the government to actually begin an ambitious agenda.
Right.
Then again, 2016, 2017, 2018, this continues, where the government is seen as the main driver of the transitional justice process. Then the government changes again in 2019, and that government says, no, we are not going to continue down this co-sponsorship agenda. We are rejecting the process altogether and we are withdrawing. That happens in 2019. And that continues in 2020, 2021, 2022, it goes on like that. So we're now at 2025, 16 years down this road, where people who are objective might look at it and say, look, governments have been given repeated chances for domestic processes to be implemented and for results to be shown, but that has not happened. So now there is a shift where we are told it's an international process that can reap results. Of course, we have a new government, and naturally the new government will say, hey, we didn't get a chance yet.
Yes.
Give us a chance.
Give us a chance.
And I think that any government in their position will do the same thing. But if you look at it from the victim's perspective, the victims have been through this process for much longer than this government.
This government has been.
And that is why the government has to show sensitivity and empathy to the victim's perspective in terms of 16 years of this process not really resulting in much. And when I say not resulting in much, I must clarify that there are some processes, some positive outcomes that have emerged from this process. For example, the extent of human rights violations that we saw in 2011, 2012, early 2012, I don't think we see those types of violations today. I think the scrutiny that we have been placed under may have contributed to the respite, right? So I think that's important to recognize. At the same time, it's important to recognize that the big picture reforms have not been delivered yet, and people will be naturally impatient.
Right.
And that understanding is very important.
It's a very detailed detailed explanation on how Sri Lanka's role and how Sri Lanka was viewed at UNHRC sessions all the way back from 2012 to 2025. Talking about the government's response, like you mentioned, the victims have been undergoing this process of accountability, some sort of reparation for all of the tragedies they've been through for 16 long years, but the current administration is barely 1 year old. So do you perceive a shift in how the Sri Lankan government has responded to findings by the Human Rights Commission of the Human Rights Council compared to past administrations? And in your opinion, what more needs to be done in that area?
That's a good question, because it's still early days. We need to often give governments time to deliver on their promises, and I think this government is just about reaching 1 year,
1 year, yes.
right? If you count the presidency as the starting point of its term. I think we have seen, certainly at least from the perspective of the Human Rights Commission,
yes,
we have seen certainly some progress in terms of institutional actors showing, or let's say displaying, a willingness to engage constructively on reform. Now, for example, if you compare the current Inspector General of Police with his predecessors, there's certainly a marked difference in the way in which the IGP is engaging the Human Rights Commission. When the Commission issued various guidelines recently on sensitive subjects, like, for example, custodial deaths in police custody, right? That's a very sensitive subject. The IGP actually reissued these guidelines as an internal circular amongst all the divisions of the police.
Yes.
Similarly, we issued guidelines some time ago on the protection of human rights defenders. Once again, that was released as an internal circular. Now, that doesn't necessarily mean that overnight the institution is going to transform. The police is still the police of yesterday.
It has its shortcomings.
And it will have its many shortcomings and weaknesses. But that leadership and that commitment to at least put a rubber stamp on an important document of this nature coming from a human rights institution,
yes,
I think that's the demonstration of some intent. And we have to recognize that intent. So I do see some shift. It's still too early as to assess whether that shift will translate into real meaningful change. That change is going to be evident in the years to come, if at all. So we have to give some time to see whether that really materializes. But I can see the intent, at least the willingness to engage. That's been a welcome change.
Right. So we're talking about the human rights aspect under the current government, particularly the leadership of Anukumara Dissanayake. Since President Dissanayake ascended to office almost a year ago, have there been any noticeable policy shifts, either positive or negative, in how Sri Lanka addresses human rights, institutionally or as a central government aspect, especially concerning media freedom or minority rights or institutional accountability? What is your perspective on those matters?
Again, I think the institutional intent seems to be there,
right,
but that now has to translate into action. And this government has some really important opportunities that it needs to seize. Let's talk a little bit about free speech,
right,
and media freedom. And media freedom not just of the traditional media, but also those who engage on social media.
Yes.
Now, if you rewind to 2022 and think about what took place when there was this crisis and people took to the street, really they wouldn't have taken to the street in the same manner if not for social media.
Right. Yes.
Social media was so pivotal.
It was a key driver. Key driver in actually organizing people, in communicating information across variety of sectors of the population. The lampooning, the criticism, all of that took place on social media. And there would not have been a people's struggle. There would not have been a Aragale if not for social media. We have to recognize that. And I would even dare say that the governmental change that we saw, the transformation that we saw
a couple of years later would not have been likely if not for Darakale. So in many ways this government almost owes its existence to social media.
Yes.
Right? Now, when this was taking place, the previous government saw social media as very dangerous, and there was a demand from political actors, particularly the MPs at the time, to regulate social media because they saw themselves as constantly being criticized on social media, and they saw it as dangerous, as a threat. And the Online Safety Act emerges out of that political motivation.
Right.
It is a politically tainted piece of legislation because it came from that intention to suppress something that political actors saw as dangerous. Right. Not that it was actually causing enormous harm to people.
In society.
People obviously will be harmed by various platforms, and that is always a question, and that requires some level of regulation. So no one is saying that online safety is not a priority. Online safety should be a priority. But the Online Safety Act, although it has those words, has very little to do with online safety. It is a politically motivated, politically tainted piece of legislation. Now, this government has nothing to do with that act.
Right.
And here is a fantastic opportunity to break from that politically motivated instrument and repeal this law. And show that this law had a politically dark past, and we are breaking from that, and we are coming up with a fresh piece of legislation that actually deals with online safety. Right? If you look at the Online Safety Act, it's just basically taking some old penal code offences and adding the word online. Right? It doesn't deal with things like denial of service attacks, cyber crimes. It doesn't deal with phishing, malware. None of the online safety issues that we actually encounter are tackled by that law. And when the Supreme Court determination was made on the bill, the Supreme Court actually made that observation. It's very strange that none of these things are included in the act. So this is a fantastic opportunity to break from that past. But I think the government is hesitating to do so, and instead of saying we will repeal and replace this act, it is now saying we will just amend it. And I think something as fundamentally flawed as the Online Safety Act can't be amended. Because now when the government is the government, those same incentives and concerns will arise, because people will be criticized on social media. People will be now the new targets of various campaigns, criticism, lampooning, ridiculing.
Especially when you're in power.
But I think the opportunity here is to show that we are different.
Right.
And I think I really hope that the government takes that opportunity and it changes the rhetoric, changes the discourse from amend to simply repeal and replace. Because I don't think anyone will oppose the idea that the Online Safety Act can be replaced with a better law.
Yes.
I mean, many people are not of that same view when it comes to the PTA. For example, the Human Rights Commission is not of the view that the PTA should be replaced with another special terror law, right? Counter-terror law.
Yes.
We are of the position that there could be offence in the penal code, but the procedure should be the same for every individual, regardless of their background. And what is happening currently is, if you happen to come from the majority community and you commit a particular offence, you will be treated as committing it under the general law. But if you come from a particular minority community, you are racially profiled, and immediately the PTA is applied. And a new law will have the same problem. So that's why a specialized counter-terror law always attracts that risk. But the rhetoric is repeal and replace. Now, people are opposed to that in many ways when it comes to the terrorism law, but they're only saying amend when it comes to the Online Safety Act. And if they shift the discourse and say, well, we are committed to repealing and replacing, I'm quite certain that a lot of people will be, first of all, relieved, and second of all, will be supportive. So there is an opportunity here, and I hope the government seizes the opportunity.
Right. So talking about the PTA, one of the biggest promises on the election stage prior to the National People's Power coming into power was repealing the PTA. Yet, 1 year down the line, there have been certain arrests made under the PTA. There was this one particular case where a young man was arrested for pasting a sticker over a certain regime or showing solidarity with another state, and there have been other cases where those who were arrested were charged under the PTA. So is the government showing signs of backtracking on its promises, or how do you view what has transpired?
So again, the rhetoric or the discourse is that the PTA will in fact be repealed,
right,
and replaced with another law. The problem is that we've been here before. We've been here back in 2018 when the government got very close to replacing the PTA with the counterterrorism law, right? There was a new law. It was gazetted. It was challenged in Supreme Court. The views were then
conveyed to the Speaker. Yes,
they got pretty close, and then it was abandoned. Then we got very close with the anti-terrorism law.
2023.
That's right. Again, the same process. We got to the last hurdle and then didn't actually succeed.
Yes.
So we have been here before, and there is some skepticism as to whether we will make the final leap.
Yeah.
This government obviously enjoys a 2/3 majority. It should be able to pass any piece of legislation, notwithstanding any inconsistency with the Constitution, as long as none of the entrenched clauses in the Constitution are violated or breached in any way. So it should be able to carry this law. The question is, what is the content of the law? And I just want to go back to the point I made earlier. The problem with special legislation that offers a separate procedural regime as an option for police officers is that the inherent biases that institutions have when it comes to particular identities will get played out again. Now, now let's take the case you mentioned. This boy that was arrested for displaying a particular sticker. He came from the Muslim community. And it was, the Human Rights Commission actually conducted an inquiry and we issued a recommendation on it, even recommending compensation. And we found that the boy's rights under Article 12, 13, 14 and a number of articles under sub-articles under 14 were violated. Right? There was a long, I think 20-page or 25-page recommendation. But what we also emphasize is that there was racial profiling in this case. This boy would not have faced the same consequences had he come from any other community. And the police profiled him as a person who could potentially commit a particular act of terrorism in the future, even though there was no evidence before any court of law or even
any criminal conduct
of actual reasonable suspicion of actual offense. And his identity drove the entire investigation. Now, what is to say that the police, with a fresh piece of legislation, which is even better than the PTA, the best piece of legislation you could ever come across in terms of counterterrorism, compliant with all the, say, human rights standards, will not be used selectively. That is the problem, right? That is why we need to call for equal treatment of all citizens before the law. Procedural regimes need to be equal.
Right.
And I think we need to trust judges to be able to make the call as to whether someone who might be a threat to society should be denied bail. Not police officers.
Not the police officers.
Not executive officials sitting in the defense ministry.
Which is what the PTA empowers them to do.
That's right. And you spoke about one case. There's another case that I won't go into right now because we are currently doing the investigation, the inquiry. But in that case, it didn't involve a detention order. It in fact involved a remand order by the magistrate. And the reason that the magistrate could not do anything else is because the PTA says the magistrate must remand. So it takes away discretion from the magistrate. So you must not have situations in which judges are disempowered, because ultimately we must trust our judicial officers to assess a situation and make the call as to whether a person should be granted bail or not. We do that for all kinds of heinous crimes, right? All the worst types of crimes, either the magistrate or in some cases the High Court judge decides whether this person should be released or not into society while pending trial. And if we can trust them with that, we have to be able to trust them with other types of cases.
Legislation,
And many of the PTA cases don't involve murder and destruction of property and bombings in the way we would assume terrorism involves. You know, what terrorism usually involves. Some of these cases involves pasting a sticker, right?
Yes.
And the accusation that sticker could lead to some communal disharmony. That is the PTA case. And suddenly the judge is stripped of
his
their discretion to decide whether the person should be granted bail or not. That kind of special procedural regime should be avoided, and that's why the Human Rights Commission actually came forward and said, no special law. We're not saying that terrorism should not be an offense. It should very much be an offense, but that can be an offense with the ordinary procedure enforced, because the police should not be able to pick which procedure to apply.
Right.
Now we need a lot more technical support, and I'm speaking a lot about the human rights violations of various institutions.
Yes.
We also need resources, and just the other day we wrote to the Inspector General of Police, and a letter will be going out to the Public Security Minister shortly as well. We promised the IGP that we will send this letter calling on more resources for the police. Because if we want to entrust this institution with safeguarding public security, we can't deprive it of resources. We have to actually allocate as much resources as possible.
Yes.
Even though we are in an economic crisis, we need to see this as an important investment.
Certainly.
And then when we invest these resources, we can expect more. So this has to go hand in hand as well. As much as we expect human rights compliant institutions, these institutions can't be starved of resources, and we've written with a long list of recommendations in terms of enhancing the resources available to the police, and hopefully with those investigative powers, techniques, expertise developing, they wouldn't need to rely on laws such as the PTA. They wouldn't need to rely on coercive interrogation tactics and methods, right? We are hoping that there is a sophistication that comes with resources, and over time these institutions actually evolve.
I see. So very quickly moving to another story that has been featuring for the past 1.5 months or so. Earlier this year, when a decision was made to re-examine or to excavate the Chemmani mass grave, which was decided on by the state that they will restart. There was much talk about it, and there continues to be talk about it, because they continue, as the mass grave continues to dig deeper, it continues to reveal more and more sinister findings, and some of which are very macabre. And there has been a call, especially from rights groups to opposition parties, to ensure that this mass grave is followed on by a process where there is transitional justice in ensuring that those responsible are brought to book, and relative or respective reparations are given to those of the deceased and the disappeared.
Yeah.
And a very interesting mention was made by the UN High Commissioner as well during his statement. He said that Sri Lanka is plagued with twin threats, which are persistent impunity and deep inequality. The HRCSL recently handed over a fact-finding report, or published a fact-finding report, and in that you highlighted institutional gaps and recommended establishing an independent office for serious crimes, including extrajudicial killing. So, Doctor, what are the key challenges in actually setting up such an institution, and how can those be addressed?
Excellent. Yeah, I think Chemmani is forcing us to reckon with the problem of impunity, right? Because when you visit the site, you can't escape the reality of impunity, because what you see is certainly not legal burials. The experts there, this is not the Human Rights Commission's own observation, but the experts
on the ground,
conveying to the Human Rights Commission that what we're looking at don't look like legal burials. They are most likely extrajudicial killings and unlawful burials. But an investigation has to be complete for that conclusion to be reached. Right? We're still at that preliminary investigation. Lot of the institutional actors, the magistrate, the judicial medical officer, the archaeological experts, even the SOCO, the scene of crime officers of the police, are involved in the excavation and doing a reasonably good job.
Yes.
But you see in our fact-finding report, there are gaps in terms of expertise, technology. We don't have the technology for DNA analysis that...
Yes. You proposed establishing a DNA bank as well.
That's right. We don't have sufficient expertise. We do have some expertise, but not adequate expertise given the number of mass graves that are now
being located yes.
in terms of forensic archaeology and forensic anthropology. So you have these gaps, and it's important that we do rely on international expertise if it is offered. We must not reject it, because sometimes Sri Lanka also sends its own experts to various countries, right? So if we see that a gap in our own expertise or gap in the adequacy of the number of experts, we must be willing to receive support. That's number one. But ultimately, it boils down to who is going to conduct the criminal investigation. And relying on the regular police officers, and I'm not saying there are no good police officers, there are plenty of good investigators in Sri Lanka, but there's a structural problem here, and I'll talk a little bit about the statistics here. If you take the number of complaints that were received by the various disappearances commissions in the 90s, that was 27,000 plus.
Right.
27,000 people made complaints to these commissions in the
unenforced disappearances.
On disappearances, right? Many of these complaints were then channeled to special institutions that were set up, a disappearances investigation unit in the police and a missing persons unit in the Attorney General's Department that began to process cases, and they identified something like 3,600 cases that they could investigate.
Yes.
Out of those 3,600 cases, we only had around 370 cases filed in the High Court, and that was by around late 1990s, early 2000s. Eventually, out of those 370 cases, they managed to secure just 12 convictions. Now, just think of the magnitude of that issue. 27,000 people have come before the commission, various commissions reporting enforced disappearance, which are basically crimes. There's no sugarcoating that. These are crimes. And you only secure 12 convictions. And the fundamental problem there is that the investigating officers are from the same institutions that are accused of the crimes. Leave that aside, and let's say this is a very special situation with a very special, episodic sort of violations, and we have not seen the same types of violations taking place at that magnitude since. Let's say that, okay. Take torture, for example. Torture is an everyday occurrence in Sri Lanka. Just last year, in 2024, the Human Rights Commission received 737 complaints on torture. Just last year, 2024. It is a serious systemic problem. We have had a Torture Act since 1994, which criminalizes torture. And since 1994 all the way up to 2025, there have been only just over 100 prosecutions. I think the number, when someone checked in 2020 or 2021, it was 115. Right. So let's say that there have been a few more since then. The official right to information request that was filed with the Attorney General's Department resulted in a particular response that counted only 6 convictions in that entire period. So 31 years of this act being in place, torture being such an everyday occurrence that the Human Rights Commission of the country receives more than 700 cases just in 1 year, and we have had only 6 convictions. Again, what is the fundamental problem here? We are having officers of the very institution that is responsible for torture conducting the investigations, and other countries have dealt with this problem. You don't have the same officers in the same institution conducting the investigation because there's a fundamental conflict of interest. You can't expect officers to actually produce good evidence that can lead to convictions. That is why the conviction rate is so low.
So is that where the proposed independent prosecutor's office will come in?
why we are saying we need an independent mechanism, and an independent mechanism that is not purely in terms of prosecutor, also investigation.
Right.
So there's a lot of talk about an independent prosecutor, but not enough about independent investigations. And we have got this right when it comes to bribery and corruption.
Right.
We have the SEBOC, the Bribery Commission, which is an independent institution with a set of experts sitting on as the commissioners,
yes.
and prosecutors and investigators that report to that commission and not to anyone else. Those investigators don't report to the regular police and are not part of the regular police structure.
Yes.
Those prosecutors don't report to the Attorney General in the same way. They are independent. And if we are serious about investigating and prosecuting state officials for serious crimes, we need to learn from that model.
So there's a template which is working.
Absolutely. Absolutely. There is a template that is working. There's a template that this government appears to be quite committed to seeing work. What can we learn from that template, and can we replicate it for serious crimes like enforced disappearance, torture, custodial death, where we expect a set of officers that are insulated from the regular police force to actually conduct the investigations. And there are plenty of examples from overseas that we can learn from.
Quote.
Yeah.
Understood. Dr. Gehan Gunatilleke, Attorney at Law and Commissioner at the Human Rights Commission of Sri Lanka, was my guest this evening. He came in to the program at, I believe, a very important time for Sri Lanka, where Sri Lanka is under the spotlight once again at the 60th UNHRC sessions held in Geneva. We also spoke about emblematic cases such as the ceremony mass grave that has been a huge talking point in Sri Lanka and also poses a challenge and an opportunity for the current administration should it get it right. Thank you very much, Dr. Gehan, for joining me to enlightening our viewers and myself on all things transitional justice, to what the great work that the Human Rights Council or the Commission is carrying out. We hope to see you again on Face to Face very soon. And that's a wrap of Face to Face for tonight. Thank you for tuning in. Take care and have yourselves a great night.